5 seconds to go. Start. The state or a public body or an entity representing a collective cause should be given some acceptable latitude. To the aforesaid principles, we may add some more guidelines taking note of the present day scenario. They are: an application for condonation of delay should be drafted with careful concern and not in a haphazard manner, harboring the notion that the courts are required to condone delay on the bedrock of the principle that adjudication of a lease on merits is seminal to justice dispensation system. An application for condonation of delay should not be delay within a routine manner on the basis of individual philosophy, which is basically subjective. Though no precise formula can be laid down, regard being had to the concept of judicial discretion, yet a conscious effort for achieving consistency and collegiality of the adjudicatory system should be made, as that is the ultimate institutional motto. The increasing tendency to perceive delay as a non-serious matter and hence lackadaisical propensity can be exhibited in a nonchalant manner requires to be curbed, of course, within legal parameters. Learned advocate for the respondent has also cited a decision of Honorable Apex Court reported in Rahul S. Shah's case 2021 6 SCC 418. He pressed hard the finding of the Honorable Apex Court in paragraphs 21 and 22 of the cited judgment and pointed out that the delay cannot be condoned when it was intentional and when it obstructed a bona fide decree holder to enjoy the fruits of the litigation. After considering the above mentioned authorities and the principles laid down therein, it appears to me that the Honorable Apex Court has always pointed out that the term sufficient cause as defined to be construed liberally in justice-oriented platform. It has observed that the expression sufficient cause employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the ends of justice, that if the life purpose for the existence of the institution of the courts. Learned advocate for the respondent pointing out paragraphs 21.4 and 21.5 of Asha Bhattacharya's judgment 2013-12 SCC 649 argued that the deliberate causation of delay and gross negligence on the part of the counsel or litigant is to be taken note of. He further argued that in this case, lack of bona fide on behalf of the appellant was glaring. In considering the submission of the learned advocate for the respondent, it appears to me that though the appellant defendant has taken some adjournments before the learned court below, but it is also not disputed factually or otherwise that one of the directors, Sushila Gupta, was not mentally capable to instruct learned advocate at that time of proceeding of the suit. Thus, the conduct of appellant defendant as alleged cannot be construed as lack of bona fide or gross negligence on their part. In this present scenario, the conduct, behavior and attitude of the appellant appears to me as justifiable. Stop.